Yes, welcome back to this very quick one. You see the issue of Nigeria sometimes. There are things I don't talk about because to me, I just get, I don't know. Nigeria seems to be a very funny country. Very, very funny and annoying at the same time. Because it seems like their judiciary is not functioning. Okay? I stumbled upon something and I said, okay, I think it's better I just talk about this very one. You see, recently, there were some sentence, carried out. There were people who were sentenced, and the two major one is, drawing a lot of attention, both at home and, the diaspora. Why? Because there are people that were accused of being terrorists. These two men were accused of terrorizing the country. The first man, is Husseini Ismail. A known terrorist leader, and he was sentenced with 20 years. And then the second man that was labeled a terrorist as the leader of the IPOP leader, the man who is fighting for the liberation of his people who have their beliefs, and they want to separate themselves from Nigeria because of some of the obvious reasons, even though we've been here saying that what we want is unity. But anyway, that's a different discussion, by the way. But this very man was given a life sentence. The man who have unalive, have sponsored terrorist activity, have taken out people, was given 20 years as a sentence in prison. And the man who had never unalive anybody directly or had never, hurt anybody was given a life sentence. You see? So this here is the reason why, you see, Nigerian sovereignty can never be respected. The moment you say Nigeria, it's like it's a joke because of things like this. Is unfortunate, but these are facts. And I was happy to see the son of a former senator who is speaking out about this. Like, he was very brutal about his truth, and I believe some senators were not really happy in this very room. I'm going to roll in the clip as well. And there are some lawyers as well who are coming to fault the sentence of the leader of that is the IPOP leader. They are faulting that sentence, and they are giving reasons why he shouldn't have been given a life sentence, even though there are facts that the man himself, there were some things he did in court that were not supposed to. I think he did that out of anger, out of frustration, out of pain. And these are the reasons why people are seeking to separate themselves from the sovereignty of Nigeria. And one has to be very, very careful when analyzing this very issue. If the IPOB believe that they can survive on their own, they can live on their own, they can excel on their own, and they don't need the Nigerian community, why is the Nigerian government not giving them this freedom that they have been seeking for all these years? There is beauty in unity, but not a forced unity, especially when people are saying they want to go, they want to be free. Why not let them be? Why not allowing them to go free? And you see, these differences is seen very clearly, and that is why it is drawing a lot of attention now. Because you sentence a terrorist with 20 years in prison, and then you sentencing the leader of an IPOP, of a movement, with a life sentence. Come on, what kind of message are you passing?
My name is Honorable Mohammed Bello El-Rufai. I represent the excellent people of Kaduna North. I'm from Kaduna State. Mr. Speaker, I'll try and be as quick as possible. It was a long day and I came late because I was unwell. Let's do this quickly. Short term, the President has rolled out a clear plan that we commend. A lot of my colleagues have rightly spoken about this and I agree. But our problem is not announcing plans. It's executing them with clear timelines. This Parliament must insist upon those timelines based on the President's recommendations. One thing I would like to add, Mr. Speaker, in addition to the recruitment, is the need for us to increase immediately the basic salaries and the welfares of police officers and soldiers, and we must find the money to do that. At present, Nigeria, put it this way, one police officer manages 600 Nigerians. The UN recommends that ratio should be 1 to 400. We are understaffed. The President has tackled that. That's one point in terms of the short-term solution. And I think, sir, you leadership and committee chairman like Honorable Jimmy Benson should keep an eye on this execution. We can't just make announcements. Let's say by February, we're about to see XYZ. That will help. In the medium term, sir, there was a conviction recently of a terrorist, Boko Haram. I believe his name is Husseini Ismail. He was convicted for 20 years by a high court. He was a Boko Haram terrorist. Nnamdi Kanu was convicted, I think, last week, and his own conviction said life sentence. I don't understand why one terrorist is getting 20 years and the other is getting a life sentence if you're saying that. I think Pastor made a good point. There's this idea that justice is served differently, and it affects the problem. Mr. Speaker, I'll conclude by saying this. I've been an advocate of state police. I've sought the wisdom of more experienced members like Honorable Sada Soli, Honorable Ado Dogwa, even yourself and the Speaker. I think the definition of insanity is doing the same thing over and over and over again and expecting different results. Somebody said that earlier. We cannot be sitting in Abuja and expecting operations to be efficient in Benue. We have to go back to communal policing. You that are older than us always tell us there was a time when if a guest comes to a community, everybody knows him. We have to get the traditional leaders involved and go back to state policing. This parliament, under your leadership, and I know the excellent work you're doing in the Constitutional Review Committee, is looking at that. Sir, no time for election talk now. We have to tell the public a timeline to roll this out. The fear that governors will abuse it always shocks me because they already have all that power. I'll finally end by putting myself in trouble as usual. The North has an issue. My honorable sister mentioned why we've become a breeding ground for such things. This is why. We are not sending our children to school. Of late, you have bandits on TikTok holding monies. The younger people, younger than myself, that have no employment and no skill because we've neglected them. It's a failure on all our parts over the years. Mr. Speaker, these young people go on TikTok and see a criminal holding minted cash. He's suddenly exciting. You want to emulate him. Mr. Speaker, we can do whatever we want to do in terms of FDI, IGR, investments, but we are failing in our primary duty, which is to protect the people we serve. We must increase the welfare of police officers. Recruitment should not be by allocation, sir. Each state should provide the exact amount of numbers. It should be digitized. We should look for young Nigerians that want to join the army to serve, not because it's a job that's seen as something else. I'm sorry if I spoke too friendly, Mr. Speaker. We are relying on you and the members of the Constitutional Review Committee to not only follow up with the President's excellent announcement, but to finally roll out state police in this country. I hope I made my point, and I really appreciate the session today. And
when in Section 36 of the 1999 Constitution, it says that the defendant must be given adequate time and facility to prepare for his defense. There are times when
he was given more than enough opportunity.
No.
Especially when he said he wanted to defend himself. The judge kept telling him
when he filed the objection, the motion to challenge jurisdiction, the judge refused to hear the motion. Objection can be brought at any point before judgment.
Wow.
No, is it because lawyers just kept quiet? You can't. This is the first judgment that we are putting something on nothing and expecting it to stand. It cannot stand. This has nothing to do with emotions. And the fact that a defendant is unruly in court, uncultured and mannerless, does not give the court, does not empower the court to pass judgment against him. The court will charge him for contempt or any other remedy available to the court. So because I've heard people say because he was unruly, that is why the court had to quickly. That is judicial blasphemy. To convict a man because he's unruly. No.
See, it's actually interesting, Barrister, you're saying. Yes, Barrister, sorry to cut in here. It's actually very interesting as you fleshing out some of these things and expose them as much as you can. But as a lawyer, is it fair to say that at this point you are questioning the intellectual dexterity of Motosh or SAN at this point, and knowing what he had going on?
Very well. What do we do on appeal? I can talk like this now because the case has ended. And they have not filed appeal. They are filing today or tomorrow. The reason lawyers cannot talk outlandishly before night because the matter is sub judice. When a court lacks jurisdiction, it lacks everything. There is an absolute miscarriage of justice in that case. Nothing comes from nothing. You cannot pull something from nothing. Nothing is equal to nothing. The judgment itself did not follow the basic legal principle for which it should be ought to have followed. When you look at the spread of the case, there are three fundamental issues. First, the law upon which he was charged had been repealed. Okay, so the statutory absence of the existence of that law itself, foils that issue. Okay. Two, the objection raised by Nnamdi Kanu in terms of the objection that relates to that the court lacks jurisdiction to that effect was not adhered to by the judge. Prejudice objection under the law, once it is brought, the law says that it can be raised at any point before judgment. So, and once it is raised, the court must first of all suspend whatsoever it is doing to attend to that. When the issue of jurisdiction is raised, the court must first of all assume jurisdiction to determine whether it has jurisdiction or not. That was not done. The third one has to do with proof beyond reasonable doubt, the material evidence, the nexus, that the unequivocal evidence that's supposed to link Nnamdi Kanu to the charge was not there. Like the lawyer said, there was no weapon. Even when you go beyond that, there was nothing direct. You are saying he made this statement, he made that statement. All those whom were affected, nobody was called as witness to testify. So the court solely relied on circumstantial evidence. Under the Evidence Act, circumstantial evidence requires corroboration before it can be fit for conviction. So when you look at the case in its totality, this three defects deflates the argument put forward by that judgment for the conviction of Nnamdi Kanu.
A very big win for Mazi Nnamdi Kanu. Another learned lawyer raises serious alarm over miscarriage of justice. Before we continue watching this very interview, let's understand the basis of what the lawyer is talking about. He describes the conviction of Mazi Nnamdi Kanu as nothing short of a total miscarriage of justice. You all remember in our previous video, a constitutional lawyer broke down the judgment and exposed what he called deep legal contradictions and judicial errors. Now, another legal expert has stepped into the spotlight, reinforcing those concerns with fresh legal arguments that shake the foundation of the entire conviction. According to this very lawyer, there are three fundamental legal principles upon which the judgment rests. According to this lawyer, he says that three fundamental legal principles upon which the judgment were actually, carried out are fatally defective. What does that mean? It means it doesn't have any stance. First, he states that the law under which Nnamdi Kanu was charged had already been repealed. Just like what I told you, Nnamdi Kanu, insisted that the law through which he's been charged, he's been tried, is a repealed law, making the prosecution legally questionable from the very beginning. Secondly, the lawyer also alleged that the court failed to properly address Kanu's critical objection on the question of a jurisdiction, a preliminary issue that must be resolved before a court can lawfully continue any trial. And lastly, the lawyer also argues that the key material evidence allegedly linking Kanu to the charges, including the so-called evidences that is presented to the court by the prosecution, was never properly established in the court. As a result of this very legal principle that is being deflated, he insists that there was no credible proof that the accused, being Nnamdi Kanu, committed the offense as alleged. And under Nigerian law, the prosecution must prove its case beyond reasonable doubts, not by suspicion, not by theory, but by solid and reliable evidence. It means the prosecution must prove guilt so clearly that no reasonable person can doubt the truth based on the evidence presented. And I ask, Omotosho, where is the evidence that was presented before you by the prosecution? Help me in the comment section. Ask Justice Omotosho, where is the evidence that was presented to him by the prosecution that made him to jail Mazi Nnamdi Kanu? According to this lawyer, the court relied heavily on a circumstantial evidence, which under the Evidence Act requires strong corroboration before it can sustain a conviction. In the words of this very lawyer, these three defects alone are sufficient to collapse the substance of the judgment. Ladies and gentlemen, let's now continue watching the interview as this lawyer lays it all bare and clear.
In criminal cases, the law says that you cannot charge someone for an offense not known to law, and you cannot charge someone for an offense that is not in a written law. So if you are charging someone on a law that has been repealed, and you have that in your charge sheet, what you need to do is to first of all address that as a prosecution counsel or the prosecution team, which was not done. Okay, criminal trial requires proof beyond reasonable doubt. It is not enough to say he made statements. To whom did he make the statement? Where are the witnesses? Where are the evidence? Okay, upon his conviction, on what basis are you arriving at his guilt and thereafter his conviction and sentencing? Okay, so we don't, in law, you cannot, apply speed and kill it on the altar of technicality.